Living trust or beneficiary designations? So I get asked this question a lot, typically by clients who are wondering if they really need to get a living trust in place. All right, so first, what's a trust? So a trust is simply an agreement between you as the creator of the trust. We usually call it the grantor or the settlor. And typically between you as the trustee of the trust, and the trustee is the person who manages the trust, so that you agree to have yourself as the trustee hold the assets or what you own versus you just holding them individually, not within the trust. And this is done so that those assets, whatever the trust ends up owning, can then pass on to who you list within the trust document as a beneficiary. The beneficiary is the person who gets the stuff, or the people who get the stuff. So it can pass to those beneficiaries without needing to go through the court system first. So without there being extra legal, extra expenses, extra time involved. So the main reason that people typically create what's called a living trust, it's a living because they create it while they're alive, but the main reason you typically would create a living trust is simply so your beneficiaries don't have to deal with the hassle and the time and the headache and the expense associated with probate. However, there's another way that you can bypass probate, and that is simply by listing beneficiaries, again, people who get your stuff, or sometimes this is referred to as a POD recipient, someone who receives the assets upon death. It's called pay on death, so POD. So you set up these specific designations on the accounts themselves. So like your bank account, for example, you can list a POD on your bank account or an investment account. This is really common on things like IRAs or 401ks, retirement accounts, or life insurance, where they typically ask you in advance, who do you want your beneficiary to be? And they will put specific people or list specific people if you do not have a trust to list as the beneficiary. All right, so which is better? Not an easy question to answer because you have to know all the circumstances, but there are several reasons that people should be wary of just using beneficiary designations or POD designations rather than using a trust. So here's a few of those. One, beneficiary designations are often limited depending on the financial institution or the particular account. So what I mean by that is sometimes certain institutions will only allow you to name a primary or a group of primary beneficiaries or PODs. You're not allowed to name secondaries in case those primaries pass away before you do. This means that asset could again be subject to probate, because if you listed someone who passed away before you and it was never changed, then it's like you never listed anyone at all. Another way they can be limited is oftentimes people want specific percentages going to specific people. Not all financial institutions allow you to designate beneficiaries in this way by percentage. And in fact, many institutions often limit the number of beneficiaries that you can even list. Sometimes even if they do allow you to list a primary and a secondary, it's literally only one and then another. I have lots of clients who want to spread out larger accounts amongst several people. This isn't always an option, again, depending on the financial institution, the bank, or the company that actually holds the asset for you. A couple of the bigger ones to be really aware of is, one, if you're naming minors as beneficiaries on accounts. I see this all the time. Bank accounts or financial accounts, life insurance, investment accounts. When you name a minor, if something happens and you pass away before that minor reaches the age of majority, that minor isn't permitted to just get whatever you left them, whatever monies you gave to them. As a minor, they can't collect that money. It can't be theirs as a minor. So oftentimes if a minor is left, someone who's typically under the age of 18, right? So someone who's not an adult yet, in order for them to receive funds that you left them as a beneficiary or a POD on an account, it may require an additional legal action called a guardianship, where an adult is basically appointed to safeguard that money for them. They're supposed to safeguard the money for them until they reach 18 or whatever age is determined within the court system. Now, this additional court action costs money, takes time, can be very expensive, can be complicated depending on the circumstances. People can fight over who's going to be the guardian. The other thing is often it requires a restricted account to be set up within the court system so that the court can monitor the funds for the well-being of the minor during their lifetime. This requires yearly accountings and ongoing legal and ongoing fees until the minor, the not yet adult, reaches adulthood, and that guardianship can be canceled. Essentially, the guardian can be discharged of their duties and the now adult can receive the funds. So we're talking, depending on how old they are, this could be years and years and years of extra legal work. Another big one is if one of your beneficiaries either already is or ends up being on government benefits, such as Medicaid. If you list them as an outright beneficiary on account, what that means is they're just listed on the bank account or the financial account as a beneficiary or a POD. They have that money, access to it, and it becomes theirs the moment you die. So it could very well interfere with their existing benefits. It could even disqualify them for Medicaid for a period of time or longer, depending on how much the money is that they're receiving and what they already have set up. If they don't have avenues to divert those funds and put them into something else so that it doesn't count against them for their Medicaid qualification, it could knock them off of their benefits for years. I see this all the time where someone could be inheriting a decent amount of money, but it's not worth it to them to forego Medicaid benefits for the rest of their life because that amount of money is not realistically enough to cover all their medical expenses, other expenses, and just cost of living and other necessary needs for the rest of their life. They need their benefits. Oftentimes people who are on these benefits, they can't work. There's a legitimate reason that they are on Medicaid, and destroying this benefit for them would be awful, like worst case scenario. So a lot of times people aren't thinking with these when they name a beneficiary. Can this person actually receive the money? The other thing that is also sometimes complicated with just listing beneficiaries or PODs on accounts, every financial institution has its own rules and its own policies. Sometimes the people who work there don't even understand them. I've had several clients who are listed as POD, payable on death, or beneficiaries on accounts, and they can't even get them because people in the institution think they need a probate. All right, so that's just a few points of why you might want to have a trust, because a trust will not leave you open to all these issues. The trust handles all of them within the document. And for sake of time, I think I'll continue this video again so I can go into more detail of why a trust will be beneficial. But I hope this is helpful. If you need more guidance on this and you're in Florida, don't hesitate to contact us. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.